Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is, can we talk about Breyer? Looking back at Justice Breyer's approach to antitrust. In January 2022, Justice Breyer of the U.S. Supreme Court announced that he would be stepping down from the bench. His 25-plus years on the bench left an indelible mark on the Supreme Court jurisprudence, and antitrust law was no exception. In this episode of Our Curious Amalgam, we'll discuss his approach to antitrust law and what we can expect from the Supreme Court in his absence. Joining me today is my co-host, Jaclyn Phillips. Hey, Jaclyn.
Hey, Christina.
So what are we talking about today?
So today we have Eric Citron with us. He's a partner at Goldstein Russell. Before joining that firm, he clerked on the Supreme Court for Justices O'Connor and Kagan. He also clerked on the District Court for the District of Columbia and the D.C. Circuit. Before that, he spent time as counsel to the Assistant AG in the Antitrust Division. Eric, we are so glad to have someone with your background here to explore the mark that Justice Breyer made on antitrust.
Thanks for having me.
And as Christina just said, Justice Breyer will retire from the court at the end of this term. So, Eric, how would you describe Justice Breyer as a jurist in general?
Well, I think, especially when we think about Justice Breyer's antitrust jurisprudence, it's important to bear in mind two things about his jurisprudence generally that informed a lot of the decisions he made. One is that Justice Breyer is definitely a pragmatist. He makes decisions on a kind of case-by-case basis based on how he thinks individual cases ought to come out. And without a ton of attention that you sometimes see from other judges about what the rule is going to be for other cases and how generalizable the analysis will be from one case to another. I think he's really focused on deciding the cases in front of him correctly, and then letting the law move sort of incrementally from there. And I think relatedly, and some speculate that this is because his brother is a district court judge in California, Justice Breyer has a kind of overwhelming trust that district courts can sort things out the same way on a case-by-case basis without a ton of specific guidance from the Supreme Court about how cases ought to come out going forward. So it has a sort of Herculean view of the talents of the district court judge. And as a result, he also isn't that focused on making grand pronouncements about the law or future cases, but instead setting up forms of analysis that he will then trust district courts to sort out, even if they're complicated. And the result is that you get a much more incrementalist approach or view of what the law ought to be doing or how it ought to be changing than you would if you were, say, comparing him to Justice Scalia, who on this measure is probably at the far opposite end of the spectrum, somebody who is extremely focused on a rule-ish approach to law and very skeptical about the ability of courts to sort out what ought to happen in individual cases without a ton of guidance. And I think that makes for a very different approach to deciding cases, and it shows up, I think, in his antitrust law decisions in particular.
Yeah, that overview, I think, gives us a lot of insight into what we're going to be hearing as we dig a little bit further into his decisions. I'm definitely going to go back to that district court point in a second. But before that, over his almost 30 years on the bench, like Christina said, did you see any changes in how he approached antitrust issues, or would you say he's been pretty consistent over that time?
Well, I think the right way to answer that question is to make a general point about something that you see in Supreme Court justices and their overall jurisprudence generally, which is sometimes they will appear to move because the law is moving around them, or the Supreme Court is moving around them without them making a lot of movement themselves. So I would say that when he joins the court and through his entire career, Justice Breyer is not a particularly progressive antitrust thinker. He's trained by Phillips. There's a consensus that has emerged by the time he becomes a judge that antitrust law was too unfriendly to big business, and too focused on the government always wins or something like that. And he is as skeptical of that old pre-Chicago regime as other people are. And that makes him look like much more of what you would call a centrist or even a somewhat conservative-leaning antitrust thinker at the beginning of his career. But then as the court begins to shift much more to the right in business cases generally, and in antitrust in particular, Justice Breyer ends up looking like he's one of the more progressive justices on the Supreme Court from the antitrust perspective. And I think that's more about the court moving than him moving. I don't think that he's changed a lot. And in fact, based on what you might call the modern disagreements or the contemporary disagreements in antitrust law, he'd look like something of a dinosaur, because he's definitely old school antitrust analysis in antitrust analysis. But like I said, I think what you're seeing is the law moving around him and not him moving.
Yeah, so let's, I think, dig into some cases and we'll see how that plays out. So I wanted to start with sort of a group of cases where Justice Breyer was deciding, what standard should be applied in antitrust cases. And looking at that, I want to jump into maybe one of his more significant antitrust decisions, the FTC v. Activist case from 2013. Could you tell us a little bit about that case and what we see?
So this case is about the Hatch-Waxman Act, which set up this incentive for generic drugs to challenge the patent status of branded drugs. And to make a very long story short, there was an incentive created for the brand and the generic to settle their patent suit in a way that would allow the generic to get a bunch of money from the patented drug holder without actually defeating the patent. What was happening was essentially a splitting of the rent between the first challenger, who had this statutory incentive to challenge the patent, and the generic drug. And they were called reverse settlements because what would happen is that the brand would end up paying the generic a portion of their monopoly rent to go away, as opposed to the typical settlement where a defendant is paying a plaintiff. And the court ends up holding that the rule that the defendants wanted, that the branded and generic drugs wanted, was that as long as the drug fell within the scope of the patent, then there would be no possible challenge. It was essentially a rule of immunity from the antitrust laws, that this would be handled by the patent laws exclusively. And the rule that the government wanted was something like a quick look analysis, which said, if this looks anti-competitive, then it is anti-competitive. And Justice Breyer ends up writing for the court that what we should have is a regular rule of reason type case where we would apply the antitrust laws fully. You would do the full analysis, and then you would decide whether or not you thought that the settlement was or was not anti-competitive. I do think that this really fits in the mold of what I was saying before. Justice Breyer both making pragmatic decisions and trusting district courts to be able to sort out what happens in individual cases going forward. Can see the much more rule-focused justices would either want a rule that if something is a reverse settlement, it's just anti-competitive, period, or vice versa, that we're just not going to permit antitrust challenges to these kinds of settlements. We're going to let them be handled by the patent law. But Justice Breyer ends up charting this middle course, which, I think does create a lot of litigation and a lot of uncertainty about what kinds of settlements are or aren't appropriate. But also preserves the ability to use the competition laws to restrict what had been a very anti-competitive practice in practice.
Justice Roberts wrote the dissent in that case, and in that case he says, good luck to the district courts. So I think that goes right along with your, view of Justice Breyer, that he had, the utmost confidence in the district courts to sort it out. But Justice Roberts maybe saw that this was, maybe headed down a different path. And I think we see that in, all the post-activist decisions and different approaches that courts have taken.
I think that's right, but this is a situation where I think a lot is achieved by making sure that there's no blanket rule of immunity, because of course what a lot of the antitrust laws are doing is not just meting out damages awards for violations, but also attempting to regulate primary conduct and prevent people from engaging in anti-competitive behavior in the first instance. So the fact that there is a line out there that you have to be worried about should constrain the behavior of both generics and branded manufacturers of drugs when they're deciding how and if they can settle their disputes in these cases. And that makes a huge difference. So I think this is an example of where Justice Breyer is being wise to maintain this pragmatic line, even if it turns out to be difficult for district courts to decide these cases. The fact that you can't violate the spirit of the antitrust laws with impunity ends up helping us a lot to make sure that we get better settlements. And we won't even know, right, that it's working, because you just won't see the settlements that would have otherwise resulted from a much more immunity-focused rule.
Well, I was going to say, I think it's interesting that private parties have decided to settle many of these disputes with a date certain at which the generic can enter, as opposed to a monetary settlement. And similarly, the FTC hasn't, I don't believe, since activists challenged or otherwise found such a settlement to violate the antitrust laws. So it is, at least in my mind, an indication of success for the opinion, despite sort of immediately after the opinion, a lot of criticism around it not providing enough guidance. There has been sort of a settlement amongst private parties as to how to handle the decision.
Yeah, I think that's right. It's easy for people whose job is to comment on the law to focus on, well, is this like a good legal rule for deciding the next case? But of course, there's a lot of other things going on here, including things that don't become lawsuits. And I think that's the area in which this decision has been most successful.
And, there's been other decisions that Justice Breyer has written that also, in the same vein, talk about, what standard should we apply? Should it be rule of reason? Should it be per se? And, going back 15 years from activists, in the 9X case, Justice Breyer, in that case, made it harder, I guess, for plaintiffs to bring certain antitrust claims. Can you tell us a little bit what happened in that case?
Sure. I mean, I think I would group 9X with, in the set of cases that I was describing earlier, where Justice Breyer is not really that progressive an antitrust thinker. And also, I think, with another set of cases that I think we'll discuss a little later, where Justice Breyer also isn't what I would call an antitrust maximalist. There are a lot of people who think basically the antitrust laws are the best competition law we have, that we should regard most problems as antitrust problems, even if they are other kinds of regulatory problems. And we should layer antitrust law on top of other regimes in order to achieve effective regulation. Justice Breyer basically took the opposite view of that dispute. His view was the antitrust laws are a kind of blunt instrument. They are very useful for generic problems in competition. But if we have regulatory approaches to things, we ought to trust the regulatory approach and kind of leave antitrust out of it. This is, again, I think, rooted in a kind of Herculean view of the capacity of what I hear are regulators as opposed to district judges to set up regimes that work or don't work and to have well-calibrated remedies and the like. And so I think 9X is a situation where the defendant in that case had violated what was essentially a regulatory duty in a way that a pro-competitive regulatory duty in a way that made the regime less effectively pro-consumer. And it could have been looked at as, well, this clearly has a anti-competitive effect, so we could apply the per se rule to that kind of violation. It clearly violated the regulatory duty, and Justice Breyer ends up saying, this isn't about, this isn't best handled with the antitrust laws. Whether or not it was a violation of the regulatory duty is up to the regulators, and to leave it at that.
There's a sense of the justice is not changing, but maybe the law changing around them. And I wanted to go to Legion for that discussion. In Legion, Justice Breyer wrote for the dissent that the per se standard should be applied to resale price maintenance. And obviously the majority said that shouldn't be the case anymore. What do you think was going on there? And is that what you would have expected Justice Breyer to do when Legion came out in 2007?
So this is a situation where I think Justice Breyer is at least a little bit unpredictable. I think you could have guessed that Justice Breyer would be on the opposite side of Legion ex ante, just because he's both pretty motivated by economic thinking and in general, I think, willing to rethink rules. He's not like a hardliner on stare decisis the way you might think of Justice Kagan or even the Chief Justice being. And yet, it is a pretty good contrast with 9X, because what I think you also see is that Justice Breyer is in 9X they're asked to add a antitrust violation where there wasn't one before for breaking a regulatory duty. Here we've got a situation where there is an existing per se rule against resale price maintenance, and Justice Breyer and the rest of the court is being asked to rethink that rule. And Justice Breyer is saying, well, we have this rule, it's working fine, there's no indication that this is like some great crisis. And so he's saying we ought to keep the rule functioning the way that it is. But again, I think you do see the court moving around him there. He's not out there advocating for new per se rules, right? And I don't think you'd ever see him taking up that banner, or you ever would have seen him taking up that banner. But when asked to displace one that's existing and working and tends to favor plaintiffs, he's also willing to stand up for the law as it is.
Thanks, Eric. And, I wanted to now go to sort of a group of cases where I think Justice Breyer has introduced, some restrictions on bringing antitrust suits. So Billing in 2007, Brown v. Pro Football in 1996, and Empagran in 2004. And what's your view on what Justice Breyer was, doing in those cases?
Yeah, so I think that these fit the mold that I was trying to lay out before pretty well. Credit Suisse or Billing is a case that's about, again, a regulatory duty and whether there's going to be an antitrust duty on top of it. And Justice Breyer ends up articulating a kind of general view that we should allow more specific regulatory statutes to displace the antitrust laws. There was the securities laws when we're talking about how to address one particular form of anti-consumer or anti-competitive conduct. If there is a regulatory regime, let's trust that ahead of the antitrust laws. It's the more specific one. Very similar in pro football, right? So that's a case about the non-statutory collective bargaining exemption. And Justice Breyer's view is we have this collective bargaining exception to the antitrust laws. It's working pretty well. It's another way of approaching the competition problems that exist in certain employer-employee relations. Let's trust the collective bargaining system and not layer the antitrust laws on top of them. Empagran is a case about one of the worst written statutes in the history of the universe, the FTAIA. It's extremely difficult to read and understand correctly. The law firm where I worked was on the other side of this case, and so I have lots of professional feelings about whether it's decided correctly or not, but leaving those aside, what Justice Breyer ends up, I think, being very influenced by, and the rest of the court, is the view that, as a pragmatic matter, the antitrust laws really oughtn't be used very broadly for the benefit of foreign plaintiffs complaining about conduct that's predominantly foreign as a violation of the antitrust laws just because it has a hook into the United States. And I think that essentially pragmatic reading of the statute and the intended international reach of the laws is what ends up having a pretty strong influence on Justice Breyer's decision.
Thanks. Yeah, and I appreciate that insight into, it's not necessarily about the antitrust laws, but what other, regimes we should look to rather than the antitrust laws, and that having a big impact on these cases.
Just say one other thing about Empagran, just because I have the opportunity to complain. This is a situation where I think, the laws, typical left-right plaintiff-defendant split isn't necessarily the only thing that drives decision making. I think you could see textualists like a Gorsuch or a Scalia having taken a very different view of Empagran or the FTAIA because they would be more influenced by, really trying to figure out what the statute says as opposed to what Congress probably meant or intended. Again, what's being urged in Empagran is a pretty expansive understanding of the international reach of the U.S. antitrust laws. And it's okay to imagine pragmatic voters thinking, oh gosh, that seems like too much. Whereas I think a less pragmatic and more rule-ish or statute-focused judge might say, well, let's just figure out what the words mean, take it from there.
Yeah. And unfortunately, there's a whole, list of cases that we could continue to talk about. And, it's great hearing your insight. I wanted to, I think wrap up the discussion of Justice Breyer's specific writings with Amex and Comcast, in which Justice Breyer dissented. Yeah,
I think these are examples of where Justice Breyer ends up being a very strong voice for antitrust enforcement with more pro-plaintiff view of antitrust law, where what is being proposed really ought to be understood as a major change in the way that the law was already working. So, there's been a general view, for example, that antitrust cases are amenable to class action status. And they really need to be, because the whole point of an antitrust conspiracy, right, is to steal like 3 cents per can of tuna from everyone on the planet, as opposed to millions of dollars from some individual plaintiff who's going to come out and bring a lawsuit. And so in the absence of effective class action litigation, no one is going to get the remedy that the antitrust laws are intended to provide. And so both Justice Breyer and Justice Ginsburg come out very strongly in Comcast, frustrated by the fact that the court is even willing to entertain these challenges to the class certification rulings in antitrust cases in particular. And an Amex, what the dissent ends up saying is that this is just what the plaintiffs had done was an absolutely ordinary form of market power analysis, where you ask, what is the relationship between the defendants and the plaintiffs, and is there market power there? Can the defendants push the plaintiffs around, or can they push, whoever the relevant market actor is around? And the court ends up, coming up with this very new concept of a two-sided market that's going to have a special kind of market power approach to it. And Justice Breyer is saying, we haven't had this, so we don't need it. It's working. The law is working fine. And I think in that space, he's always been a very strong voice for the pro-plaintiff approach.
I know I said that was it on the cases, but I just had one quick question. How do you see this? Obviously, Justice Breyer joined, the majority in Twombly. Do you see any tension there? Have you ever heard that, Justice Breyer regretted being on that side of Twombly, or is that SCOTUS folklore? Jesus.
Sure. So it's a great question. I mean, I'll say that I don't know what Justice Breyer's regrets are personally, and even if I did, I probably wouldn't tell you. But I will say that Twombly was a case that seemed very antitrust specific and very much about a very specific kind of problem, which is, can you just say there was a conspiracy without evidence behind it, and thereby get into the very difficult and expensive world of antitrust discovery, or should you have to have a little bit more? And I think it's come to be a much bigger, much more pro-defendant kind of general, here's a first crack at summary judgment before summary judgment kind of approach to the law that I think lots of people who signed that opinion probably didn't think it was going to be when it was first written. So I don't think it would be strange to believe that Justice Breyer would be regretful about where that decision has gone, without questioning, again, I think the wisdom of the case limited to the specific context that Justice Breyer thought he was, or the rest of the court thought they were deciding when they decided that.
So, Eric, we would be remiss if we did not also ask you a little bit about your predictions for the court going forward, and in particular with respect to the nomination of Judge Ketanji Jackson to the Supreme Court. What do you think, her position will be on antitrust jurisprudence, and how will that compare to Justice Breyer's?
Well, it's really interesting because I think we're in a kind of unknown moment for antitrust in general. I think there's a lot of movement within both parties towards I would call it more progressive, but maybe it's more pro-enforcement or more monopoly skeptical view of the antitrust laws than we've had in the past. I don't know Judge Jackson's antitrust law decisions in particular, and it's always a little dangerous to extrapolate too much from what people have decided on the courts of appeal, because they're often constrained by what they view as the governing Supreme Court precedent at the time. But I think one thing that's important to bear in mind is that Justice Breyer is not fundamentally a very progressive antitrust thinker. He is holding the line against some movements that are more skeptical of antitrust in some spaces, but even there, he has this view that other regulatory regimes, for example, are better suited to their specific problems than the antitrust laws are. And that's not necessarily a widespread view. So between the nomination of a new justice to replace Justice Breyer and this kind of flux that you're seeing in the party's general views about antitrust, I think it's quite possible that the court is actually becoming a little bit more progressive or more pro-plaintiff on antitrust than you would have thought it would be at a time where, Justice Ginsburg has been replaced by Justice Barrett, and Justice Breyer is going to leave the court. I think there is a lot more uncertainty there than I would have said there was just a few years ago. You see it showing up in cases like Apple against Pepper, for example. I think based on a general skepticism of the plaintiff friendliness of the Supreme Court, you would have thought that the plaintiffs in that case were doomed to failure, and in fact, they managed to pull that one out. And I'll be very curious to see where the court is in some of these cases going forward.
Yeah, it's interesting. You talked about sort of the law changing around the justices, and certainly a time where it seems like the law may change around the justices. And Justice Breyer came onto the bench, as you mentioned, at a time when there was increasing skepticism of antitrust enforcement. Judge Ketanji Jackson may be joining the bench at a time when there is also a sort of similar transition, but the opposite, where there's increasing desire for antitrust enforcement. So certainly something to look for, and whether there'll be also more antitrust litigation and more SCOTUS jurisprudence on it will be something to look for as well. Eric, this has been an incredibly engaging and interesting conversation. Before we let you go, we do like to ask all of our guests a few questions. First, tell us something about yourself that those that work with you wouldn't know about you.
Have had a series of one-year jobs throughout my legal career before I got to this one. But my favorite one-year jobs have not been legal at all. I taught snowboarding between college and law school at Loon Mountain, which is not really a mountain, in New Hampshire. And in college, I had a gig playing guitar at a bar for my senior year. So, if I could do it all again, I probably would have focused on those more engaging careers.
A man of many talents. Hopefully you keep up with those hobbies. Maybe relatedly, any advice you have for young lawyers who are looking to do what you do?
Yeah, I guess what I would say is if you're going to make a career of it in the law, the most important thing is to find areas of the law that you find fun or engaging. There's every job, including teaching snowboarding, becomes a job really quickly once you're doing it. You got to get up in the morning, you got to put on whatever uniform your job demands of you, and kind of drag yourself to the office, even if it is something you like to do. But it is infinitely easier to do if it is something that you find genuinely engaging and motivating on a day-to-day basis. So I do what I do now at a small, mostly plaintiff-focused Supreme Court law firm because I wanted to be doing antitrust cases for what I call the good guys in most cases. And that was the only way that I could find it, worthwhile to get out of bed in the morning and go to work. And I would recommend basically the same to everybody else. Find something that really motivates you, that you find passion doing. And if you can't, you should probably find something else.
Great. And now for our last segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
Eric, can I ask you to pick a number 1 through 10?
7.
7. How would you spend the perfect weekend?
That is a good question. Well, I just came back from skiing in Steamboat Springs in Colorado, snowboarding, and I had about as much fun on that week-long trip as you could have. So I guess my perfect weekend would be on a mountain somewhere, riding around and enjoying the scene afterwards.
And what's been your favorite place to snowboard, ski?
Well, I particularly like Utah, both for the snow and for the relatively laid-back scene. I like Snowbird, which is in Little Cottonwood Canyon outside Salt Lake City. And there's basically nothing to do there except for snowboard, drink weak beer, and go to sleep and wake up and snowboard again the next day. And that's sort of how I like it. So I guess that's my favorite place.
It's your perfect weekend.
There you go.
Sounds lovely.
Eric, thank you again for joining us today. And for all of our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.